Court calls number 23-09-28697-CV in the interest of Scarlet Harris Powell et al. In the 454th Judicial District Court of Medina County. Court is streaming outside of Medina County via Zoom and YouTube. Are there any objections?
No, Your Honor.
No, Your Honor.
No objections.
No objection.
With that, Mr. McKeska, would you please begin the announcement? Mr. McKeska, I think you were muted.
I was, Judge. Drake McKeska, attorney for the department. Ms. Hernandez.
Kimberly Hernandez, permanency specialist with Belong.
Christy Knott, permanency supervisor with Belong.
Catherine Shove, permanency supervisor with Belong. Erica?
Yes, hi. My name is Erica Yaku. I'm a protege observing.
Richard Solomon, attorney for Mr. Roscoe. Mr. Roscoe, will you unmute and announce, please?
Daniel Rasco, father of Scarlet Powell.
Alani Pearsall, attorney for Miles Benz. Mr. Benz, will you introduce yourself?
Miles Benz, Paisley's father.
Brandon Wong, attorney for Grace Benz.
Deborah Fuller, attorney for the attorney and guardian ad litem for the children, Your Honor. Ready?
Jill Roden, Tri-County CASA.
Anyone who's not an attorney or would be giving testimony, please raise your right hand. Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. Put your hands down. We are here today to recommence trial that we commenced initially on August the 27th. We heard quite a bit of testimony that day, entered several exhibits, and the court recessed and reset for today. My understanding is that in the time that has elapsed since then, Ms. Bentz has executed a relinquishment. Is that correct, Mr. Wong?
Correct, Your Honor.
And you've received it, and all the parties have seen it, Mr. McKeska?
Yes, Judge. It was filed on September 11th, 2024.
Okay. Have the parties been able to discuss all ramifications of the final order to this point?
Yes, Judge. I think there's still some maybe slight issues with regard to Mr. Bentz that may need to be worked out. But I believe other than that, everything else is squared away.
All right. So what would be the plan today to prove up the relinquishment and then work on some other things? Do you all need to confer, or how do you want to proceed?
Really, I mean, I guess it really depends on how you want to handle it, Judge. I don't want to necessarily keep everyone here unnecessarily. But I know that, Ms. Pearsall, Ms. Fuller, and I have been kind of exchanging messages and talking this morning. So there's just an issue with regard to Mr. Bentz's visitation post final order that need to be worked out. So if you want us to see if we can iron that out quickly, then we could just proceed and wrap everything up.
Anybody else have a problem with that plan?
No, Your Honor.
I mean, it might be more effective just to handle the relinquishment and then be able to release Mr. Roscoe and Mr. Saldivar. But
And that works too, Judge.
That's fine.
Okay. So then you want to prove it up, release them out of the case, and then confer about Mr. Bentz.
That work, Judge. That way we can release all the other unnecessary parties.
Okay. I think that's a good use of time as well. All right. Then if you would, you're going to have Ms. Shove testify as to the relinquishment?
Judge, I would like to recall Ms. Hernandez. I know that we wrapped up her testimony previously, but given the change in circumstances, I believe she'd be the appropriate witness.
Yeah, and that's my mistake. It would be Ms. Hernandez. So you may proceed. We're still going to call this a recommencement of trial, obviously, but you may recall Ms. Hernandez, and then I'll allow the parties to cross as necessary. So you may proceed.
Thank you, Judge. Mr. Hernandez, can you please state your name for the record?
Kimberly Hernandez.
And how are you currently employed?
I'm a permanency specialist with SJRC Belong.
Okay. And Judge, would you enable the share screen function, please?
Yes, I will. It's done.
Thank you, sir.
Welcome.
Mr. Hernandez, can you see the document pulled up on my screen that's been pre-marked as Petitioner's Exhibit number 8?
Yes.
And can you please identify that document for me?
It's an affidavit of voluntary relinquishment of parental rights.
Okay, and who is the relinquishment for?
Grace Spence.
Okay. I'm gonna scroll down. Did Miss Bence execute this relinquishment in front of 2 witnesses?
Yes.
Did she also execute it in front of a notary for the state of Texas?
Yes.
Okay. And at the time she executed this affidavit, was she represented by Mr. Wong?
Yes.
And did Miss Bence have the opportunity to review this affidavit with Mr. Wong?
Yes.
And do you believe that Miss Bence's questions regarding the relinquishment were answered by Mr. Wong?
Yes.
And do you think that Miss Bence, or do you believe that Miss Bence fully understood the legal ramifications for executing this document?
Yes.
Did the department promise Miss Bence anything in exchange for the relinquishment?
No.
Did the department threaten Miss Bence in any way, shape, or form in exchange for the relinquishment?
No.
Is it your understanding that Miss Bence executed this relinquishment freely and voluntarily?
Yes.
Okay, and that she did so believing is in the best interest of her children?
Yes.
Okay, at the bottom or on the verification page, there's a section labeled consent to designate as managing conservator. You are the agent of the department currently, is that correct?
Yes.
Okay, and are you giving your consent to name the department as the managing conservator of at least one of the children?
Yes.
Okay. Judge, I would like to introduce Petitioner's 8.
Any objection?
No objection.
No objection, Your Honor.
No objection.
No objections.
Petitioner's 8 is admitted.
Thank you, Judge. Judge, with that, I'll pass. I believe that I got best interest testimony in our previous setting.
Mr. Wong, any questions for Ms. Hernandez?
No questions.
Mr. Saldivar?
No questions, Your Honor.
Ms. Pearsall?
I believe you testified trial day 1 that you were waiting to staff a case to see if you could start working the reunification with Mr. Bence.
Yes, ma'am.
And has that staffing happened?
Yes, it has.
And has that been approved?
Yes, it was approved for overnight visits to begin.
And has Mr. Bence started unsupervised overnight visits?
Yes, he's had one.
Okay. And can you tell us the date and like how long that visit was?
Yes, it was last weekend. That was the Sunday to Monday from 8 a.m. to 8 a.m.
And did that visit go well?
Yes, it did.
No concerns?
No, ma'am.
And so is it the department's plan to continue unsupervised visits with Mr. Bence at this time and his child?
Yes.
Now the questions.
Bowler?
Mr. Hernandez, are you asking the court to terminate Ms. Rice based solely on her affidavit of relinquishment?
Yes.
And you feel that's in the best interest of the children?
Yes, ma'am.
And in regards to Mr. Roscoe, he will be named permanent managing conservator of Scarlet, correct?
Correct.
And in regards to Paisley, the department at this time is asking to be named permanent managing conservator.
Yes.
I'll pass the witness.
Redirect?
No, Judge.
Any other questions for Ms. Hernandez as it pertains to the relinquishment?
No, Your Honor.
All right. My understanding is at this time we want to take up. I heard the testimony that Mr. Roscoe, department intends for Mr. Roscoe to be permanent managing conservator. Do you want to put on any evidence of that before we move on to the next step?
No, Judge. I mean, I guess just make argument with regard to the relief the department's requesting regarding Scarlet.
Okay, let's go ahead and do that.
So, Judge, because of the unique circumstances, I am asking the court to at least consider an oral motion to sever the cases today. I believe that we're going to need 2 separate final orders with regard to each individual child. And so if the court does grant the motion to sever, then I'm requesting the court enter an order with regard to Scarlet that will terminate the mother's rights based solely off the relinquishment that was proved up today. I find that the termination of that parent-child relationship is in Scarlet's best interest, and also make the necessary findings. The department made reasonable efforts to return the child home, but despite those reasonable efforts, a continuing danger still exists. I believe the testimony that was elicited on day 1 of the trial establishes each and every one of those requests by clear and convincing evidence. We're asking that Mr. Roscoe be named as the sole managing conservator of Scarlet, and that the court dismiss the department as the temporary managing conservator today, and then also dismiss the respective appointed attorneys from their appointments with regard to Scarlet.
Okay. Mr. Wong, any response as it pertains to Scarlet?
No, Your Honor, that's correct.
Mr. Stolivar?
Judge, we're in agreement. My client has his child. He wants to be severed out of this case and be sole managing conservator of this child, Judge. I think she's been there and he'll meet all her needs. And we are in agreement with that request, Judge.
Ms. Pearsall, do you have any argument on this?
Your Honor, I agree that the cases should be severed. Outside of that, I don't have any objections to any of the requests.
Ms. Fuller?
Your Honor, I am in agreement and feel like it's in Scarlett's best interest for the mother's rights to be terminated and Mr. Roscoe to be appointed the permanent managing conservator. He has done an excellent job with Scarlet. He has the patience of a saint, to be honest, and he has really worked hard with her to get her so she could have a stable lifestyle. Very proud of, very proud of Mr. Roscoe. And I know that Scarlet will thrive in his home up there in New York. I had an opportunity to meet with them in New York, and he's a very, very good father. And I'm glad to see this case end this way so they can move forward.
Wonderful. Thank you. Ms. Roden?
House is in agreement with what Ms. Fuller shared. We believe it's in Scarlett's best interest to remain with Mr. Roscoe. Like she said, I mean, he's been proactive in setting up therapies, working with the school to get her the interventions that she needs. And every month when I meet with her on FaceTime, I've seen just an improvement in her ability to stay focused and the way that she reacts to Mr. Roscoe's redirection during those calls sometimes, to her behavior. I mean, he's really shown that he's committed to this and is making a good impact on Scarlet. So we're just happy to see her have the permanency and stability she deserves.
Thank you. Perhaps I missed it. Was there an actual motion to sever filed, or is this an oral motion?
It's an oral motion, Judge. I don't believe I've actually filed one.
I didn't think so either. And I'm assuming based on the arguments, there's no objection to lack of prior notice on the oral motion to sever.
No objection, Your Honor.
All right, then the court will grant the department's request to sever these cases. The court will sever out the case as to Scarlet. Can assign, I'm not sure, I can't remember how they do it in Medina County, but we'll assign a new cause number for Scarlet and Paisley so that we can differentiate between the two cases. But as to Scarlet, the court finds that all parties entitled to citation and notice were duly cited and served. The trial commenced August 27th, and as to Scarlet is being finalized today, September the 16th. Court finds that it has jurisdiction over the subject matter and the parties. This is the court of continuing exclusive jurisdiction. No other court has, or there's been no evidence presented that any other court has continuing exclusive jurisdiction over this child. The court finds that based on the evidence throughout the trial record, that the department has proved by clear and convincing evidence that the mother, Grace Bentz, pursuant to Chapter 161.001B1K, did, on or before this suit was filed, execute a voluntary affidavit of relinquishment. Court finds that it's in the best interest of the child to terminate her rights based solely on that relinquishment. Court makes the finding that the Department of Family and Protective Services / Belong made reasonable efforts to return the child to Grace Bentz throughout the course of this case. Court finds that there's considerable evidence in the record of multiple attempts that the agencies made to work with the mother, provide her with a service plan, provide her with resources and referrals, provide her with visitation, and to try to return the child home and reunify, but there was a continuing danger that continuing danger existed because the mother's issues that brought the children into care, despite all of those efforts, persisted. And it was not in the best interest of the children to return to her. It was, in fact, in the best interest of the children and remains in the best interest of the children for her rights to be terminated pursuant to 161.001B1K. Court finds it's in the best interest of the child for father, Mr. Daniel Rasco, to be named as the sole managing conservator of the child, Grace Bentz, and have all the rights and duties pursuant to the family code. Court finds that it's in the best interest of the child to dismiss the Department of Family and Protective Services / Belong as the temporary managing conservator. Court also finds it's in the best interest of the child, as to Scarlet's case, to dismiss the attorneys who represent the parents or the child in their respective appointments as to Scarlet only. Court finds that it's also well, I don't think Casa is appointed as a guardian ad litem. It's the attorney. It's in the best interest of this to dismiss the guardian ad litem for the child as well. Are those all the orders that you need us to Scarlet, Mr. McKeska?
Judge, I just need you to, I guess, correct something for the record. Prior to the commencement of the trial on the 27th, you did order a transfer and consolidation of the Harris County order for Scarlet into this case. And so I just want to make sure that that's clear on the record.
Yeah, and that's correct. That case was consolidated into this case. And so as of now, this is the only court of continuing exclusive jurisdiction. Is that sufficient for you?
Yes, Judge.
Okay. Mr. Rasco, I want to echo what I've heard some of the other folks say in this case. I'm super proud of you. You came in, you stepped in, and you got to work immediately. You were able to get reunified with your child through, channels that put her in another state, which is no easy feat. And through that all, as Ms. Fuller said, you're very patient. You've been very patient with the child. And as Ms. Roden said as well, everything is going very well. So I want to give you a round of applause and tell you congratulations. But also, I'm very happy for Scarlet because I think that this is not only a long time coming, but she needed you and you showed up in every way. So good on you. I'm proud of you. Any objections to releasing the attorneys here as to Scarlet's case?
No,
No
Your Honor.
objection.
I guess that would just be Mr. Saldivar at this time, would it not?
Yes, Judge.
Correct.
Okay. Mr. Saldivar, thank you for your time and your service. I'll find that you have diligently completed and satisfied all of your duties in this case, and send me a bill.
Thank you, Judge.
Bye. You are excused. Mr. Rasco, you're excused. Good luck to you, sir.
Thank
Have a
you.
good day.
Judge, I think if you since you terminated mom, we can release Mr. Wong as well.
Well, we're only handling Scarlet's case at this time, correct?
Judge, I mean, I would have no objection to the court making the specific findings regarding termination as to the mother and then releasing Mr. Wong as well. I don't see that as an issue.
I don't either. I'm fine with that. Okay. Mr. Wong, you okay with that?
That's fine, Judge. Just confirming termination for Paisley's on the same grounds as for Scarlet.
Correct. Just for the record's sake, court will find that through the termination or through the relinquishment that Miss Vince executed, even though the cases were severed, that does also impute to Paisley's case as well. The department proved by clear and convincing evidence that as to Paisley as well, termination of the mother's rights under 161.001B1K is in the best interest of the child, and that the same findings and orders as to the reasonable efforts made and the continuing danger also exist in Paisley's case. So I will terminate her rights as to that child under the same grounds and same findings. I'm going to hold off on making any further orders as to Paisley, considering the parties still need to work some things out as to Mr. Bentz. But I think that that covers everything as to Miss Bentz in toto here, and that Mr. Wong can be released. Does anybody have any objection?
No, Judge.
Okay.
No objection, Your Honor.
All right, Mr. Wong, thank you for your time and your service in this case. Appreciate you being here today. I'm glad you were able to all work something out. And if you don't have anything further, you are excused.
Thank you, Judge.
Thank you. Okay, do you all want a breakout room to talk about anything else?
Yes, please.
Yes, I think we can work it out fairly quickly, yeah.
Yeah, I think just Deborah and Drake and me, Your Honor.
Well, and CASA too, they have an opinion.
Okay. I've got Ms. Pearsall, Ms. Fuller, Mr. McCaska, Ms. Roden. Anybody else needed in there?
No, Judge.
No.
Oh, okay, that room is open. I'll check on you in 5-10 minutes. Ms. Wolf will be in a brief recess. Thank you.
A little longer than a few minutes later.
I'm going to go back on the record and cause number 23-09-28697-CB in the interest of Powell. What have the parties established?
So, Judge, with regard to the rest of the relief requested, and by agreement of the remaining parties, we are asking for the department to be named as the sole managing conservator of Paisley, for Mr. Bentz to be named as a possessory conservator. We're asking the court to maintain her current placement, and placement is working on becoming licensed. And once placement has become licensed and the requisite time period has elapsed for PCA benefits, we'll be filing a petition to modify in order to transfer sole managing conservatorship to Ms. Venegas with the PCA benefits. And then with regard to medical support, child support, we're asking the court not to enter any sort of medical support, child support at this time. And then finally, with regard to possession and access, absence an agreement of the parties, and following the next two overnight visits between Mr. Bentz and Paisley, we're asking the court to grant Mr. Bentz an expanded standard possession order, where he will be picking the child up from her daycare at the beginning periods of his possession, and then returning her to Miss Venegas's home at 6 p.m. On the last day of his period of possession and access.
Are those all the terms?
Yes, sir.
That's your understanding of the agreement, Ms. Pearsall?
Yes, Your Honor. And Mr. Benz, can you unmute and tell the court that you're in agreement with those, please?
I'm sorry, explain what?
Is this your agreement that you made?
It's some of the agreement Emily and I have been working out, yes.
Okay. Is this the agreement that you want the court to approve?
To be honest with you, I would like to be Paisley's primary parent, but I have no problem with the scheduling with Emily or anything like that. I feel like we're good at co-parenting, but I would like to be Paisley's primary parent.
Okay, you understand that the agreement that was just read into the record does not make you the primary parent?
Yes, I understand that.
Okay, so what I'm asking you is, are you asking the court to approve the agreement as it is, despite what you wish would happen, or are you telling the court that you don't agree to this?
No, I do not agree to it.
So you don't want me to enter this agreement?
No, sir.
Okay, well, it looks like we have a problem then.
Judge, what I'd ask then is because we've already taken care of the other parties, if we would just recess trial at this point, give us another reset date and send us back to mediation so we can work out these issues, or try to work out these issues.
I think that would be appropriate because it sounds like Mr. Bentz is needing some counsel, and I don't know that forcing that to happen this morning and then pigeonholing an agreement would be the best thing to do. We've got plenty of time. Our 90 days started August 27th, correct?
Yes, sir.
Okay. Miss Greenlee, what do we have? I know, well, let me preface it with this. We don't have anything left in September. October is going to be sparse. So what's the closest thing we have in October, Miss Greenlee? And we're going to probably need what, if it goes to contested, 3 hours?
I'm sure. I think that would be an overestimation, but that would put us on the safe side.
Okay.
I agree with Mr. McKesk. I don't think it'll take that long.
Okay.
But better safe than sorry.
Well, then let's look for something 3 hours in October if we have it, Miss Greenlee. This is the court's order to appear. I'll memorialize it in writing, but all parties that are here are under notice that I'm making the order an open court, that your order to appear. Okay, that'll be the order of the court. Thank you all for your time and your service. All parties are excused. Ms. Wolf, thank you for being here today. It was good to see you. And I wish you all luck with your mediation. That'll be the docket for today. All parties are excused.
Thank you,
Thank
Judge.
you.